On Friday, April 25, 2026, Taylor Swift's intellectual property company executed a quiet legal maneuver at the United States Patent and Trademark Office. Her legal team submitted 3 specific applications. 2 of them asked the government to trademark the sound of her speaking voice. The third asked to trademark a specific photograph of her performing on the Erasers tour stage. The Patent and Trademark Office is now reviewing a request that lacks a legal precedent: whether a human being's natural speaking voice can be owned as intellectual property, the same way a company owns a logo. To understand why she filed these applications now, we have to look at a multi-year pattern of artificial intelligence attacks against her. The first escalated in early 2024, when a flood of sexually explicit AI-generated images of Swift spread across social platforms for hours before moderation teams could intervene. By August 2024, the attacks became political. Donald Trump shared AI-generated images on his Truth Social account, depicting fake endorsements, including a fabricated image of women wearing shirts that read, "Swifties for Trump." Swift responded by endorsing Kamala Harris. In her statement, she directly cited the deepfakes as the reason she needed to be entirely transparent about her actual voting plans, signing off as a childless cat lady. But the third attack vector is the most economically dangerous: invisible commercial exploitation. Bad actors have used AI to clone her voice and likeness for fake cookware advertisements, deceiving fans and diverting commercial revenue through thousands of clips that can be generated in minutes. Currently, the main defense against this is a legal concept called right of publicity. These laws dictate how a person's likeness can be used, but they vary by state. And while fighting a fake video with a real, truthful statement is effective, it requires the damage to already be done before a celebrity can respond. The world's most powerful pop star was trapped in a reactive legal vacuum. Her team needed a defense strategy that could strike before the images even started to spread. That strategy came from TAS Rights Management, the company built specifically to manage Swift's assets. They bypassed state privacy laws entirely and found a proactive federal workaround hiding in plain sight: the sound mark. A sound mark is a type of trademark designed to protect distinctive audio branding. The law recognizes a specific sound, like the Metro-Goldwyn-Mayer lion roar, as ownable property. The government has granted these for decades to protect corporate audio triggers, like the classic 3-note NBC chime. They are also used for commercial mascots, legally protecting things like the Pillsbury Doughboys giggle from being used by other companies. For 70 years, this specific law protected roaring lions, chimes, and animated doughboys. It was never intended to protect the biological sound of a natural human being. That barrier cracked in January 2025, thanks to actor Matthew McConaughey. The U.S. Patent and Trademark Office granted him a sound mark for an audio clip of his famous movie line, "All right, all right, all right." He proved that a specific human catchphrase could be federally owned. Swift is seeking a significant expansion of that ruling. She isn't trademarking a short, scripted movie quote. She filed 2 promotional recordings of her natural speaking voice, using them as a legal anchor to claim ownership over her vocal identity in a commercial context. Now, this creates a rigid legal trap. Under the old system, suing an AI creator meant navigating 50 disjointed state privacy laws. If these voice recordings are granted trademark status, any AI that generates a fake commercial sounding like those clips commits trademark infringement. That is a clear-cut federal offense with nationwide jurisdiction and consistent financial penalties. Her legal team is taking a rigid corporate law and turning it into a proactive nationwide shield against commercial AI deepfakes. This specific strategy aligns perfectly with the philosophy Swift applied to her music. She spent 6 years fighting to re-record and own her master recordings so no one else could control her art. The third application adds a visual layer, trademarking the specific combination of her iridescent bodysuit, the pink stage, and her pink guitar. It is a targeted expansion of her legal defenses, treating her specific stage identity as a registered brand. She is rushing to build this legal wall right now because artificial intelligence is advancing rapidly. Deepfake voice clones are becoming indistinguishable from real human audio to the human ear. She is applying her philosophy of total ownership to her own biological identity, claiming it before anyone else has the chance to replicate it. The United States government in Washington now faces a deeply consequential decision. If the applications are approved, a brand new category of intellectual property is born. Every actor, musician, and public figure will immediately flood the Trademark Office to secure their own voice. If they are denied, it sends a signal to the entertainment industry that the current legal system is not equipped for the AI era. In a world of perfect digital cloning, should a human being have the fundamental right to legally own the sound of their own speaking voice?